I've given a lot of speeches and publications, worked in patent litigation. Here's some resources. Dale Carnegie, How to Win Friends and Influence People. Changed my life. And that's about culture. It's not so much about logic. It's not about science or technology or law. It's about expressing appreciation of people, recognizing their importance, avoiding criticizing them. Very hard to do. And better than reading the book is to take the course. Getting to Yes is about negotiation. It is the seminal book on negotiation. Next week, I'm going to be mediating a multi-million-dollar patent infringement dispute. And I'm thinking about, okay, what are the interests between these parties? How can I help them each to accomplish their interest and reach an agreement? There's a saying that a good settlement is one where both sides go away unhappy. So how do you help people to do that? It's by helping them see that their interest is better served by settling now than spending millions more, and they've already spent millions, but by spending millions more on legal fees. Robert's Rules of Order is a great book. Most of it you don't need, but it has a lot of good philosophy about how to conduct meetings. U.S. Patent and Trademark Office I mentioned, and Google Patents is a great resource. So remember this, engineers. You are an inventor. And when you create something new to solve a problem, it's probably patentable. Now, is it worth investing $10,000 to file a U.S. patent application? Well, that becomes more of a business consideration. Is this product actually going to go on the market? And it's hard to predict. And the biggest inventions are the ones that are the hardest to predict whether they're going to really amount to anything, like the digital computer. Questions?
Thank you, Mr. Beem, for your talk. It was very entertaining and insightful. And my name is Daniel, and I wanted to ask you, with regards to just the social aspect of IP. So let's say I have no idea what IP is, no patents. I don't really care. I'm just, the user of the iPhone. What do you think are the effects of, Samsung and Apple discussing this, and how does this play a role in the long run? So will I end up paying more for the iPhone because they had this dispute, 10 years ago? And so I want to know how end customers, are affected by the existence of patents and IP.
Usually patents raise the price in the short term. That's why people get patents, is because they want to have the exclusive market for whatever that product is for a limited period of time. An example, I went through a Target store a few years ago. I did a course like this for the U.S. Army engineers and scientists, and I wanted some examples. So I looked for products that were patented, and I found a little mag-light flashlight with a little key ring on it. It just has one little AA cell. And then there was a Rayovac one right next to it. And the mag-light had a lot more features. The Rayovac had just a switch and a bulb and a case and a battery. I actually didn't have a battery. You have to buy the battery separately, of course. The mag-light had the same stuff, but it had a lot more features, and it had 30 patents on it. And it sold for about twice as much. So the reason pharmaceutical companies want patents is because they can charge 20 times as much for the product as it will cost when it goes generic. And it's painful to pay that extra price. The rationale for it is that if it weren't for the patent, the pharmaceutical company wouldn't bother investing. Apple wouldn't bother making the technology if somebody else could just knock it off and make it cheaper. So in the short term, you pay more for patented technology. Now, as for patent litigation, that probably increases the cost too, but maybe not as directly. I think that tends to come more out of the company's pockets and reduces the company's profits because what really determines the price of a product is what people are willing to pay for it. So Jobs was upset that it was going to cost $2,500 to come out with the first Apple computer that he wanted to sell for $2,000. But he wanted to have all those features in it. So I don't know if that really answers your question very well. Other questions? Yes.
What would you be able to tell about the patents in biological and natural compounds? For example, I know in the early 90s, the end of the 90s, a lot of Amazonian natural species had compounds, patents over Japan, Europe, and even here in America. And some of them were put down by organizations like WTO. So what is today's idea in this case of patents?
Biological, you have to do something new with it. You can't just take an existing material and patent it. So what the pharmaceutical companies like to do is they'll clean it up and they'll dose it and they'll put it in a formulation. Now it's something new. And if there's anything new about it, and if it's non-obvious and it's useful, then it's patentable. So it's hard to generalize, but there are a lot of patents on things that are biological. I had one case that involved beta-glucan, which is a byproduct of, among other things, the brewing process. And it's the active ingredient in brewer's yeast. And it's good for the health, very good for the health. But a lot of people don't like to take brewer's yeast because it doesn't taste very good. So these people got patents on every way to make beta-glucan. And they've made a new product. It's still biological, but it's something that did not exist in nature. I hope that helps.